For most American families, the biggest thing that ever changes hands isn't money, it's a house. 38% of Americans say real estate is part of an inheritance they've received or expect to receive. And 72% of that real estate is somebody's primary residence, not a portfolio, and not a check that clears on a Tuesday. The actual house, with the actual dent in the kitchen doorframe where somebody measured your height in pencil. Cash splits 3 ways in about 4 seconds. A house doesn't split at all. On January 1st, 2026, the oldest baby boomers turned 80. Boomer deaths are projected to climb from roughly 2.6 million a year now to 4 million a year by 2037, and the peak won't arrive until the middle of the 2040s. Cerulli Associates puts the coming transfer at nearly $124 trillion by 2048, which is the number you've probably seen quoted. Hold it loosely. In July of 2026, economists at Visa published a hard reality check, and their figure is $36 trillion after you subtract liabilities, retirement spending, charitable giving, and taxes. That's about $515,000 for the average household that inherits anything at all. Visa's chief economist, Wayne Best, put it plainly, when people toss around $100 trillion, they forget the deductions, and boomers are carrying a great deal of mortgage debt. Nobody can tell you which of those two numbers is closer to right, and honestly, the gap between them is the point. Somewhere between $36 and $124 trillion is going to move, and an enormous share of it isn't liquid. It's siding and shingles, and a lot in a county you haven't visited in 11 years. 75% of Americans who have inherited or expect to report at least one problem with the process. Unexpected costs at 28%, family disagreement at 23%, confusion over who even has the authority to make a decision at another 23%, probate delays at 20%. So why does one house leave a family intact while the identical house on the identical street puts another family in front of a judge for 2 years? Probate is the court process that changes the name on the deed after somebody dies. In 2026, most cases run between 9 and 18 months, and the all-in cost frequently lands between 4 and 7% of the estate's gross value. 2 states means 2 separate proceedings. A family that fights stretches the clock further. None of that pauses the taxes, the insurance, the lawn, or the mortgage, which keep arriving on schedule the entire time. And 56% of American adults hold none of the 5 core estate planning documents. That number isn't just flat, it's falling. Will ownership drop from 31% to 26% in a single year, even though 73% of people say estate planning matters to them? When nobody files anything at all, the title simply never changes. A dead man's name sits on the deed while 4 children, then 11 grandchildren, then 31 great-grandchildren each inherit an invisible fraction of a house some of them have never seen. Attorneys call this heirs property, and it's one of the least stable forms of ownership in the country. Fewer than 1 in 4 black households has a will, compared with more than half of white households. And that gap traces directly back to Reconstruction and Jim Crow, when the legal system was close to the people who most needed it. Roughly 1/3 of all black-owned land in the South is heirs property today, about 3.5 million acres, worth about $28 billion. The Department of Agriculture calls it the leading cause of black involuntary land loss, tied to a 90% collapse in black-owned farmland between 1910 and 1997. What that status does day to day is specific and mostly invisible from outside. You can't borrow against the house because no lender will accept a title nobody can prove. You frequently lose the homestead exemption, which adds thousands to the property tax bill every single year. And then, after enough years of that, you slide toward tax foreclosure over a sum that wouldn't cover a used car. This isn't a rural problem or a southern problem. It's a paperwork problem, which is the only category of problem that's completely preventable. There's also a tool nobody warns you about called a partition action, and any co-owner can file one. A sibling who inherited 10% has precisely the same right to force a sale as one who inherited half. The action typically consumes 5 to 15% of the property's value in fees and carrying costs, and takes 6 to 18 months from filing to distribution. Investors understand this arithmetic perfectly, which is why they buy one heir's fractional share for very little, become a co-owner, and force the whole property to auction. The law is starting to catch up. Slowly, the Uniform Partition of Heirs Property Act is now enacted in 24 states, the District of Columbia, and the United States Virgin Islands. In California, for any case filed since January 1st, 2023, co-owners get a court-ordered appraisal and a 45-day window to buy out the sibling who wants to sell. The judge has to weigh 7 factors, including ancestral attachment, who actually lives in the home, and who has been paying the taxes and the upkeep. That's a genuine change and worth knowing about. It also isn't retroactive, and it isn't everywhere yet. So for a lot of families, it arrived a decade too late. So parents reach for a shortcut. Put the kids on the deed now, while everyone's healthy and getting along. It sounds like love. It's probably the most expensive gesture in American estate planning. Gifted property carries your old cost basis to the person receiving it, while inherited property is revalued to fair market value on the date of death. Take a house bought for $200,000 that's worth $1.2 million today. Gift it, and your children are standing on roughly $1 million of built-in taxable gain. Let them inherit it, and that gain is close to zero. Almost everyone has this backwards, which is the part that gets me. The federal estate exemption in 2026 is $15 million per person, and barely one estate in 1,000 pays the federal tax at all. Almost nobody loses this money to the estate tax. They lose it to basis quietly in a deed signed at a kitchen table with the best intentions anybody ever had. There's a second cost too, and it arrives with no warning. The day you add your child to that title, your child's divorce, your child's lawsuit, and your child's creditors all acquire a legal interest in the roof over your head. You didn't give away a house, you gave away control of where you live. Two honest tools exist instead. The first is a transfer on death deed, now available in 32 American jurisdictions. You keep everything while you're alive, you can revoke it on a Wednesday, and your heirs still receive the step up in basis. But if your named beneficiary dies before you, and you never named an alternate, that share lapses straight back into the probate estate you were trying to avoid. It also only answers one question, which is who gets the house. It says nothing about how. 3 names on a deed with no instructions is the same fractional ownership this whole film has been about. The second tool is a properly funded living trust, and everything depends on that word, funded. You keep control while you're alive. Live in it, sell it, refinance it, change your mind, change your beneficiaries. At death, the trust does what a bare deed can't. It can grant one child the right to buy out the others at appraised value. It can hold a struggling heir's share in protection instead of handing them a check they can't survive. It can name who sells, when, and on what terms. The fair criticism here is a good one, so take it seriously. An unfunded trust is excellent insurance you never paid the premium on. If the deed was never actually retitled into the trust, then the trust owns nothing, controls nothing, and the house goes through probate exactly as if you had done nothing at all. What matters isn't the binder on the shelf. It's the deed recorded at the county. None of this is exotic, and none of it is only for wealthy people. 62% of Generation X, the generation inheriting first and hardest, holds no estate documents whatsoever. Oddly, the youngest buyers are further along than their parents. For Generation Z, buying a home is now the single biggest trigger to finally make a plan, and 57% of them say they take that guidance from the real estate agent, lender, or title officer already sitting across the closing table. Have the conversation while everyone is alive and nobody is grieving. Find the current deed. Confirm the trust actually holds the house. Name a contingent beneficiary. Then write down what you want to happen and why, because the instruction is what prevents the lawsuit. Go back to that front door, the lockbox, the mail piling up in the slot. Somebody's entire working life bought that house, one payment at a time. And what happens to it comes down to whichever piece of paper is on file at the county on the day they die. Your family will inherit either a home or a lawsuit, and you're the one who decides which one it is. Families very rarely end up in court over a house that came with instructions. If this was useful, subscribe and like the video. There's more coming.